So, good morning, everyone, and welcome to today's CPD. This is the second CPD of our procurement series, and today's talk will be on the modification of contracts, public procurement, and the rules on material change. Our speaker today is Orla Sheehy from McCann Fitzgerald. Orla specialises in public procurement law with experience in both contentious and non-contentious aspects of tender processes, together with invaluable insights into the political environment in which contracting authorities operate. Orla's knowledge and understanding of public procurement law is unparalleled, but what sets her apart is the practical and commercial way in which she approaches the often tricky issues that arise during tender processes. She acts for the Irish Central Bank, National Transport Authority, National Development Finance Agency, the Transport Infrastructure Ireland, and the Office of Public Works, among others. Orla also lectures widely on public procurement law issues, including as part of the Trinity College Diploma on Construction Law and Contract Administration and the King's Inn Diploma in Public Procurement Law. So without further ado, I'm going to hand you over to Orla for today's CPD. If you do have any questions for Orla throughout today's session, please pop them into the Q&A box at the bottom of your screen and we will try to get to as many questions as possible. So thank you and over to you, Orla.
Thank you very much, Grace, and hello, everybody. So, as Grace said, I'm here to talk to you today about modifications of contracts. And some of you may be wondering, Orla specialises in public procurement. Sure, isn't public procurement all about getting to contract signature? Why is public procurement relevant after I've signed the contract? Hopefully, by the end of today's session, you'll have a good understanding of the long tail of public procurement law and how it can impact contract management itself. So, in terms of an overview of what we're going to talk about today, I'm going to do a bit of a rundown of the law on material change and modification of contracts. And this is one area where we're lucky we have quite a lot set out in the actual primary legislation. So, there's a relatively clear roadmap for the principles at hand. I'm going to talk about a little quirk that has arisen in recent case law, and that's the idea of estimating your contract value at the start and how that can maybe sometimes operate as a bit of a constraint on authorities who are trying to manage live contracts. And then I'm going to talk about how practically you might try and de-risk this issue if you are running a competition or supporting a contracting authority who is running a tender process. How might you try and take certain steps at the outset to try and leave yourself in a good position to manage the way in which a contract will always need to change somewhat? So first and foremost, why are we talking about this at all? So, public procurement is fundamentally concerned with the process that contracting authorities follow to identify the winner of an opportunity. So, most of public procurement is focused on how do you set the criteria to choose the winner? What are your pre-qualification thresholds that exclude people or let people through the gate for participating in an opportunity? How do you record the decisions that you've made? All of that is about what happens before you sign the contract, how you choose the person that you're actually going to award the contract to. But since about early 2000s, the European courts have expanded the impact of procurement law and have actually made it quite clear that procurement law doesn't just finish at the point in time in which you sign the contract with the winner. It has an impact on how that contract continues throughout its duration. And this is because of the principles of equal treatment and transparency that underpin all of procurement law. There was a case called Pressatext back in 2006 in which it was held, well, if you award a contract for something and you followed a public procurement process and then you make big changes behind the scenes and that contract turns into a completely different opportunity, in reality, you haven't actually run a procurement for the contract that you ended up getting delivered. You ran a procurement for a completely different contract. And therefore, what procurement law treats, it treats a very changed contract as effectively being a contract that there was never a procurement for in the first place. And so, because of this, it is not permitted in procurement law to make material changes to a contract that is concluded. And it's a fairness point. The idea is if you go to the market and say, I have this wonderful opportunity for a contract for oranges, And then all of a sudden, behind closed doors with the winner, it's no longer a contract for oranges, it's a contract for apples. Well, it's just not the same opportunity. You might have had a very different competitive dynamic. People who are active in the Apple market never knew that this could be an Apple's contract. Maybe they didn't participate at all because they're not in the orange business. It's really just making sure you're not fundamentally changing the goalposts in a way that means that the competition that you ran might not have got you the right result or might not have attracted the right people. So that's really what underpins this whole law. So our starting position is therefore a change to a contract is prohibited unless it is blessed by one of the safe harbors that are set out in the directive. So the directive is Directive 2014-24. It's implemented into Irish law in the 2016 regulations. And in both of those, the relevant article that sets out all of these safe harbors is Article 72, Regulation 72. That would be your Bible if you're advising an authority on making a modification or a change to an existing contract. You would be trying to find a home for it in the safe harbors in Article 72. Otherwise, it is actually not the same contract that you awarded through a competition, and it's prohibited. Just to give you an indication of quite how strict this rule is, there is a case from the European courts in which the court held even if you're settling a dispute, even if the reason you're making changes is to actually try and resolve litigation or an arbitration, that doesn't mean that you can still make a modification that is not blessed by one of the safe harbors. So in the Finfrania case, it became quite clear that the contractor just couldn't do everything that they had signed up to do. And there was a big dispute happening in the background, and the authority, in trying to resolve it, came to a settlement agreement. And part of what that settlement agreement covered was a reduction in the scope. So the authority said, listen, we know you can't do everything you've promised us to do. We will only ask you to do this portion of the original scope. Let's all just forget about the rest. And this somehow made its way to the Court of Justice, and the Court of Justice said, "Oh, that's still a material change, even if it was to dissolve or diffuse and resolve some sort of dispute. It is still a material change, and it doesn't seem to us to be blessed by one of these safe harbors, so it is prohibited." Um, the material change rules also can apply even if what you're trying to do is ensure continuity in the face of, say, a procurement challenge. So in the CHC case that's listed there on the slide, there was a procurement challenge in the High Court. Because the challenge was in being, the Minister for Transport was prevented from signing the new contract. And the incumbent said, well, don't worry, you can keep us in situ until we've resolved this litigation. We'll stay and we'll keep providing the service under the current terms. You can extend our contract. And the court says, I'm not sure they can extend your contract. That seems to me that it could be a material change to do that. So that's an indication of quite how seriously courts take these rules. Just because the authority is very much between a rock and a hard place doesn't mean that it's necessarily okay to make a modification to an existing contract. So what I'm going to do now is I'm going to go through the safe harbors. Now, luckily, and this doesn't always happen, but luckily in the case of material change, the European Commission, when it was drafting the directives, recognized that authorities can't be forced to crystallize a contract in aspect that will never change and it will never be modified. Of course it will. It will have to be able to respond to changing circumstances. And so what the Commission did was they included quite a number of separate safe harbors in the directive that allow for changes. And what you find yourself doing, and certainly I find myself doing a lot in my practice, is looking at the different situations that have arisen on a contract and trying to see if you can fit them in to one of these safe harbors so that you can justify it and argue that it is permitted. So we'll go through each of the safe harbors in a bit of detail, and then I'll go through some sort of examples and case studies. The first safe harbor that's set out in the directive in Article 72 1A is the most useful. It is essentially a blessing for any change that is teed up in the original contract and procurement documents. So that's not to say that a one-liner saying, "Oh, we might do X, Y, or Z" is necessarily sufficient. It has to be a sufficiently clear, precise, and unequivocal review clause, e.g., a price revision clause or an options clause. And that legislate or that provision, that clause, must set out the nature and scope of the possible changes and the conditions under which they may be used. You also cannot use this to alter the overall nature of the contract. So if you're asking somebody to build you a car park, you can't put a clause in that says, "Oh, and by the way, in addition to building that car park, we might ask you to build a metro." That obviously would be a complete change in the overall nature of the contract. That would be stretching this too far. But this is a really useful safe harbor because it is absolutely standard, especially in construction contracts, for there to be relatively detailed variations clauses that importantly set out how things are to be costed. And where you have a detailed price variation clause, or say, if it's say a professional services contract with an indexation mechanism, these things all allow for modifications to be made within their parameters relatively easily. Those types of clauses will usually satisfy this safe harbor. What you can't do is rely on a very, very broad clause that just says the parties can agree any change in writing. That's not good enough, and we know that from UK cases. Ideally, the clause should explain what sort of changes should be made, how they will be costed, that kind of thing to make sure that we're satisfied that it fits within this safe harbor. Helpfully, there is no need to publish a modification notice if you're relying on this safe harbor. So every time you say move with indexation at the end of a year in a professional services contract, you don't have to publish some sort of notice on the e-tenders website saying, by the way, we've moved indexation. That's something that can all just happen in the normal contract management sense, and there's no need to publish any sort of transparency notice about it. This is the most useful of all of the safe harbors. Now, some of you may be thinking, this isn't a change at all. Why is Orla telling me that I can apply the provisions of my contract? Sure, of course I can apply the provisions of my contract. I would agree with you from a contract law perspective. Procurement law is a bit funny. Procurement law takes a different view on this. This is a European concept, and Europe requires that we treat the application of the contract's own terms as being a modification, and therefore we are where we are. But luckily, we end up in the same place. If the contract allows for something explicitly, we're okay from a procurement perspective as well. The next safe harbor that is worth mentioning is Article 72(1)(b), and this is when you need more works, services, or supplies from your original contractor, and where you can't change contractor because it wouldn't work to put another contractor in for economic or technical reasons, e.g., interchangeability, interoperability with existing equipment, or whether it would cause significant inconvenience or substantial duplication of costs to try to do that. The real classic example of this type of safe harbor being useful in practice might be you've got a bit of kit, you might have bought the kit from an OEM, and that OEM might have the exclusive right to maintain, or maybe the only technical know-how. It rests with the OEM to maintain that piece of kit. You might have purchased a support package of 7 years. There might be another 5 years of usable life left in that kit, and you want to get a little bit more support. That is something that this clause very clearly facilitates. You couldn't get someone else in to maintain that kit, and it would cause you significant inconvenience or substantial duplication of costs if you had to change OEM because you'd probably have to buy the kit again. This sort of thing happens with intellectual property rights as well. This is a clear example of where the legislation recognizes that sometimes you're sort of tied in to somebody, and that is understood and justified, provided that whatever you do doesn't exceed 50% of the original value of the contract. So that means if you want to buy more years of support, you have to do a bit of a calculation and see how far will that get us before I hit 50% of the original value. Now, you can use this safe harbor a number of times, and that 50% is considered separately each time. It's not cumulative, but that has a warning sign, which is you can't split things up artificially to try and get out of the 50% limit. So if there's a circumvention attempt, that won't save you. Importantly, if you are relying on this safe harbor, you do need to publish a transparency notice. You do need to tell the market this is what you're doing, and you need to justify it. So you'll need to put up a note on the official journal of the European Union and on e-tenders saying, we had this contract, it was worth X amount, we are modifying it. The reason we are modifying it is we need more works, supplies, and services, and we came to the following conclusion that nobody else could provide those work supplies or services, or it would be completely uneconomic to try and get somebody else to provide them, and for the following reasons, and it doesn't exceed 50% of the value. So that's what you'd have to put out there into the market if you were relying on this safe harbor. The next safe harbor that is relevant is 721C, and this is really summarized as unforeseeable circumstances. So, where a diligent contracting authority could not have foreseen the issue that has given rise to the need for the modification, well, then you can do what you need to do. This happened a lot during COVID. A lot of contracts were extended during COVID because they were coming up to expiry. And during that period of time where the entire world had gone into chaos, a lot of procurement processes were cancelled. And that was understood as being a justifiable reaction to the chaos that was COVID. Now, not everything that you might think is unforeseeable will necessarily be deemed by the law to be unforeseeable. So the Aircom case is a UK case, or sorry, Northern Ireland case, apologies, in which the Northern Irish court it didn't kind of decide the matter, but it speculated that maybe a procurement challenge isn't unforeseeable, that a diligent contracting authority should foresee that a procurement that they run might be challenged, and that therefore they might not um, be able to rely on this safe harbor to extend their incumbent arrangement, because they really should have potentially foreseen the possibility of a procurement challenge. That's an interesting observation from the court there. Again, if you are relying on this particular safe harbor of unforeseeable circumstances, it can't exceed 50% of the value of the original contract, subject to the same conditions I mentioned a moment ago. And again, you must publish a notice in the official journal of the European Union and on e-tenders explaining that you've made this change and explaining why you believe that is justified on the circumstances. The next safe harbor that is helpful and relevant is 721D, and this is where you actually change your counterparty. So who you choose as your winner is the key thing that you do during a procurement process. I have picked bidder A over bidder B. I'm entering a contract with bidder A. And then contractor A as he becomes, what happens if you need to change the identity of that contractor? Now, in the normal circumstances, you couldn't really do that. That would be a big change. So in my example of bidder A and bidder B, you wouldn't be just switching out the winner and putting in their competitor and saying, "Oh yeah, that's still the same contract, nothing to see here." That would obviously would make a mockery of the original competition. But what happens if it's not something sort of untoward like that? It's actually there's been a corporate restructuring, or there has been, some sort of internal reorganization, or the shares have been sold, or something that's much more day to day, much more in the normal course of business. But you do maybe need to, strictly speaking, change the identity of the person who has signed and entered that contract with you. So whether it's a novation or something like that, this particular clause allows for that. It allows for it where there is either an unequivocal review clause, and that I think has to be more than just novation on consent. It has to be something a bit more detailed than that. Or where there is a clear corporate restructuring, such as an insolvency, a takeover, a merger, provided that whoever is stepping into the shoes of the original contractor meets all the original pre-qualification criteria. So you can't step out a Topco and replace them with a €2 company with nothing sitting behind them. You have to ensure that you're still getting the same caliber of person who won that competition and who got through the pre-qual. But assuming that you're happy that it's the same kind of bundle of resources and somebody who's able to meet all of those threshold and criteria, then it is permissible if it's a legitimate corporate restructuring. You can't, however, use this as an opportunity to sneak in other modifications to the contract. So you do need to ensure that if you are relying on the safe harbor, you're not changing anything else. There is no need to publish a modification notice if you are relying on this safe harbor. Article 72.2 is very handy. This is a really nice little safe harbor that is basically takes away a lot of the agonizing that you might have to do in some of the other safe harbors. If it's just really low value, off you go. So this allows for modifications that are valued both below the EU threshold. So that's your 220 odd for services and your 5.3 odd million for works. Those values, if it's below those values and also below 10% of the original contract value for a supplier services contract, or below 15% of the original contract value for a works contract, well, then off you go. No need to worry. No need to publish notice. No need to do anything. It's just fine. You don't need to really interrogate too much the reasons for this. Now, there was a mistake in the original Irish transposition of this rule, and if you look at the Irish regs, it might give you the impression that it's okay if it's below either the European thresholds or 10% or 15%. That's not the case. It has to be below both. That has been resolved in an amendment to those regs. So just do exercise caution if you're looking at those safe harbors. That particular one is a bit of a false friend. You have to make sure you're not making any modification to the overall nature of the contract. So, you have to make sure it's still within the same envelope. It's the same type of contract. Now, there is one limit on this, which is if you do use it, you're eating into a kind of an overall limit, an overall pot that you can use this for. They are assessed on a cumulative basis. So if you make a number of small changes, you might find you're hitting this threshold pretty quickly, and they do have to be considered cumulatively. The last safe harbor that is set out in the legislation is the original, the OG, from the first case that we had on material change in the European courts. And it's a bit of a touchy-feely one. It's change is okay as long as it's not substantial. What does substantial mean? A substantial change is any change that could have attracted different participants into the tender process or could have led to a different outcome at either pre-qual stage or tender stage. It is anything that changes the economic balance of the contract, anything that considerably extends the scope of the contract, or any change of contractor outside what's permitted by the safe harbor I mentioned a moment ago. If a change doesn't trigger one of those kind of tripwires, it is presumed not to be substantial and it's something that you can go ahead and make, and you do not need to publish a notice. This is a really tricky one to apply because it necessarily relies a little bit on hypotheticals. How will you ever know whether some change would have changed how people behaved in the original competition, would have attracted different bidders into the process, would have led to a different outcome? It's honestly very, very difficult to know. But this is one that we find authorities often end up looking into in quite a lot of detail, and it can be a useful way to justify a modification. I'm going to talk now a little bit about some of the case studies that we've seen in the law on this, just to give you a sense of how this analysis tends to work in practice. Just for your information, all of those safe harbors are separate, so you just need to find one home for a change. You don't need to try and argue that a change is compliant with all of those safe harbors. Often they won't be. Often you'll try and find one or maybe two homes at best for a particular change, and that will absolutely suffice. There is no need to justify a change under more than one safe harbor. One is enough. Okay, so in terms of the case law, this is a whistle-stop tour. There's quite a lot of case law on this particular topic, a lot of it at European level. But it's, I think, a useful explanation of what I mean by this concept of change, what will be problematic, what won't be problematic. So the first case to mention is Wall or Val, and it is a reference to a court decision from the Court of Justice about 15 or 16 years ago now. And normally changing out a subcontractor won't be a particularly big change, but in this case, what happened is Val tried to substitute the key subcontractor who was actually doing most of the work and who had been absolutely key to them winning the competition. They would not have won the competition if they hadn't been partnered up with this key subby. And that key subby was really the heart of the performance of the contract. They tried to change the subcontractor, and the authority permitted it. And then someone else challenged, and the Court of Justice said, yeah, no, that was a material change. This key subcontractor was actually the decisive factor in Val winning the competition in the first place. So it was a material change to permit them to just walk away and to get somebody else involved. There is a recent enough case relating to an Italian bingo concession. And this is again interesting. Modifications don't necessarily have to be something that's agreed bilaterally between the parties. A modification can be something that's imposed by legislation. Very fact specific. Not every legislative change is going to be a contract modification. But in this particular case, it was very specific to how certain concessions were being run. And it was a top-down imposition of new terms in those concessions. And the Court of Justice said, yeah, the fact that the parties didn't actually bilaterally negotiate this doesn't mean that it's not still potentially a modification to that contract that is potentially contrary to EU procurement law. So maybe even that legislation could be unlawful. We have a similar case in Ireland, Copymore, which was to do with a printing and photocopying framework. And the minister issued a circular, and the circular said, oh, by the way, that framework that got set up, all public authorities have to use it. It's not just an option for you to draw down, you have to use it. That fundamentally changed the commercial dynamic in that framework. And suddenly, if you weren't on that framework, you weren't just missing out on the possibility that somebody might draw down, you were missing out from the entire public sector business. And you didn't know that at the time that the prequel was being run. And the court in Ireland said that that is a material change to that framework. That is a top-down direction from the minister that has fundamentally changed the nature of this competition. The Finn Franja case that I mentioned at the start is another interesting illustration of how this principle might work. That was where, again, the reduction in the scope could be a material change. Now, obviously, you might think, well, why is that material? Why we're not making it any more attractive for anybody? But actually, when you think through the way in which competitions are advertised, it's absolutely possible that somebody might not have gone for this opportunity because it was too big for them. And if they had known that actually the scope was more circumscribed, they might have participated in the opportunity and they might have been successful. So to materially reduce the scope, if that's not provided for in the tender documents, is actually potentially a problem as well. The CHC case is an interesting case because it's Irish. It's not a final decision. It was a sort of preliminary view taken by the court, but the court was certainly concerned that extending a 10-year contract by 1 year or possibly a little more, so bringing it from 10 to 11 or 12, as well as a small amount of additional services, that could be a substantial or material extension of the scope of that contract. So that was, again, a kind of an illustration of how that will get considered by the court in practice. The Belgium case, the BT Belgium case, was a useful indicator of how the court will consider circumstances that are truly unforeseeable. In this case, COVID-19 meant that the re-procurement that was being run by the Commission got cancelled. The organisation was thrown into chaos by COVID-19. Resources were diverted to, emergencies, and they didn't finish a re-procurement process that they had running along in the background. So they decided to extend the current or the existing contract. There was a challenge, and the Commission said, sure, this was an unforeseeable circumstance. This was clearly Article 72(1)(c). We had to cancel the competition for unforeseeable circumstances, so we had to extend the incumbent's contract. And the court said, yeah, that's exactly what this safe harbour is there for. And then the last European case I'm going to mention is Commission versus Germany. And this is a case where it was for motorway maintenance. They increased the service area, so like increased the amount of the network that was being maintained, by 25%, and it worked out at a 15% increase in the contract value. And the court said, yeah, that's just too much. That's a considerable extension of the scope, and that's something that is problematic and is a material change. Now, the thing about European case law is you don't always get a lot of the information about the facts, and the way they're written doesn't allow for as much analysis on the way the particular tests are being applied. So it's always nice when you have Irish or UK case law where there's a lot more detail on the facts and the underpinning analysis provided in the judgment. So I thought I'd go through a recent enough UK case, which is, I think, quite a good explanation of court being sensible about these kinds of changes. So this is a case called James Waste versus Essex County Council, and it is a case about a waste disposal contract. And it was quite a complex contract. There was a lot of mechanisms there for gate fees and particular facilities being able to take certain waste, etc. Now, they ended up adding in an additional waste disposal facility, a new disposal site for a small period of time. And there was some amendments to the fees to accommodate this. And another local incinerator operator got very annoyed because his own site was suffering, and he brought a challenge. Now, in terms of the headline vital statistics of this change, it was worth under 1 million in an 8-year contract that was worth 100 million overall. So, it was 1% less than 1% of the value of the contract, but still above the EU threshold. So you couldn't get in that de minimis, that low value exemption. So the court had to think, well, is this okay? Is this a material change, or is this justified? And while the court said, okay, safe harbors have to be construed narrowly, they're an exemption from procurement law, so we can't be blasting open the gates and interpreting them very broadly, it is still the burden rests on the challenger, on the complainant, to show that it's not justified. That's quite nice for authorities to know that there's a presumption that the change is justified, and it's for somebody who's complaining to prove otherwise. The court also confirmed, which is also nice for them to say outright, that you only need to find one safe harbor. You don't need to find multiple safe harbors to justify a change. And the court explicitly endorsed a common sense approach. Now, in this particular case, they couldn't rely on the contract change clause because they hadn't followed it to the letter. There was a contract change clause there. It might have been enough, but they didn't actually follow the change process, so they couldn't rely on that. But they were able to rely on the fact that it wasn't substantial. So that touchy-feely safe harbor that I mentioned at the end, that was able to get them home and justify this amendment. So there was no suggestion that any other tenderers would have bid if they had known that there was a possibility that they might be allowed to change the waste disposal facility for a number of months towards the end of the contract. That just wasn't deemed credible by the court. There was no suggestion that the economic balance of the contract had changed. So even though there had been a different fee negotiated for this new waste disposal facility, it was a fee that preserved the economic balance of the contract. It wasn't a windfall. It was consistent with the way things were being priced generally in the contract. And therefore, it was not a change in the economic balance. And then finally, in terms of the actual value, 775K over 100 million is just not considerable. So the court was happy that this was okay. This wasn't something anybody should be getting particularly het up about. I'm going to move into just a kind of a new topic that is related and has been causing a lot of concern for authorities, which is, okay, we understand all of that stuff about changing contracts, but when we're defining the scope of the contract at the outset, contracting authorities are always asked to put an estimated value of that contract in the advert, in the notice that goes up on e-tenders saying, what is the estimated value of this? And that has always been a bit of an art, not a science. It's very hard for somebody in the contracting authority to fully quantify what a contract might look like at the end, bearing in mind all of the options and extensions and various other things that might happen. And traditionally, nobody was too worried about that. Nobody was kind of particularly concerned about how you came to that contract estimate. It was understood that it was really there for two purposes. It was to make sure that we catch above threshold contracts so that nothing is not subjected to procurement law when it should be. Make sure that we're identifying the procurements that should be deemed to be of EU threshold value and above threshold and should be publicly procured. And then it's also there to give the market a sense of the scale of the opportunity. But there was no suggestion that it had to be an exact science. Whereas there's a recent case law on this that has actually given rise to a bit of concern that the estimated contract value, at least in the case of framework agreements, is actually a cap. So there was a case in 2017 that was incredibly confusingly reasoned and nobody paid a huge amount of attention to. It did seem to suggest that the advertised value of a framework was a cap, but it said a lot of other contradictory things. So we sort of could kind of treat it on its merits as being a relatively unique and not particularly well reasoned case. However, in 2020, Simonson and Wheel came along. This is another European case on framework agreements, which said, no, no, Authority Grantia was correct. When a framework agreement is advertised, the value of the contract that's put into that official journal notice is a cap. You cannot exceed that cap. Excuse me. So what the court said is once the advertised value of the framework is met, you should stop using that framework. It should cease to have effect. Now, luckily, the court did say the Article 72 safe harbors are available. So you can go above your cap if you have a safe harbor to justify it. But that's a lot of work. It's no longer a case of, well, this is the value was not really a cap at all. It was all just an indication, and we don't need to worry about justifying going above the cap. Now, for framework agreements, particularly, you actually have to use those Article 72 safe harbors to justify any spend, any euro that is spent that is above the value of the estimated contract value that was put in the framework advert from the very start. This is a very, very big ask of a contracting authority. Does seem to expect that a contracting authority has a crystal ball. It's not necessarily fair, but it is the situation that we are in, that specifically for framework agreements anyway, you would need to be using those Article 72 safe harbors to justify any overspend, even if the scope of the contract is exactly the same as the advert. And that can be very difficult and very onerous. And if you can't find an Article 72 safe harbor to justify any overspend, strictly speaking, you're meant to go back out for a new framework. In all of this, whether it's frameworks or traditional contracts, you will get the impression from this whole law on material change and modifications that there's a lot of pressure on contracting authorities at the outset to have a crystal ball and to explain exactly what the scope of their opportunity is in a way that's maybe not reasonable. So, I mean, when we're talking about spend, things like inflation can completely overtake what people understand at the start of a contract, especially in a long-term arrangement. Increased costs due to global instability, supply chain disruption, the additional need for works or services because of changed circumstances, continuity where that needs to be preserved, technological change, scope creep, all of these things happen in every contract. And the Article 72 safe harbors help, but they're not always a complete answer to everything because sometimes they just don't cover circumstances in which might be economically reasonable to make a modification. The best you can really do is to try as much as you can at the outset of any procurement to de-risk variations and de-risk the scale and scope of the opportunity as much as you can. Principally, this means brainstorming with the contracting authority at the very outset. What might change? You can never get this fully right, but you will certainly be in a better position if you've taken the time to brainstorm with the contracting authority as to how things might develop and modify during the term. So, are there options that they might like to draw down if they get additional funding, say? Are there extension options that need to be built in on, say, professional services contracts to make sure that the team can follow the underlying project? Where is the risk of inflation going to lie? If it's a bespoke contract, do you need to have a bespoke inflation mechanism? There's all lots of kind of it's all very well and good to say, well, I'm not bearing the risk of inflation. I'm a contracting authority. I shouldn't have to do that. The downside is that if you don't allow for some inflation, then you might get higher cost bids up front, and then you might find yourself in a position where, in reality, things may need to change because of global circumstances. And if you don't have a clear, precise, and unequivocal clause in your contract, you'll be in a procurement difficulty if you then agree something that is not in your contract. So build in flexibility in the procurement documents and in the contract from the outset. Consider tailored indexation clauses, consider scope flexibility, build in options, build in provisions for technological change, make sure that your price can accommodate these kind of options. Make sure that there's enough of a breakdown on unit pricing or line items to enable you to quantify the costs of particular variations. All of this will put an authority in the best possible position to be able to manage its contract within the four walls of the contract itself, not have to worry about procurement law, not have to worry about trying to argue that something was unforeseeable or some other safe harbor. The best thing we can do is put the authority in a position to rely on that first safe harbor. The contract already deals with this. In terms of framework agreements specifically, there has to also be a really, really, really careful analysis of the potential estimated value of the contract for the purposes of the notice. So what we are seeing people do a lot at the moment is you have an estimated value, which is kind of your reasonable, realistic estimate with a bit of float, covering all of the likely options, extensions, etc. And then separately, a maximum value, a much higher cap. And that's the one that people are saying is the cap for the purposes of the case law that we saw from the ECJ. So you're still giving people a realistic sense of what the opportunity is likely to cover, but you're also building in a separate and much higher cap, which is the thing that triggers the need to make an Article 72 safe harbour argument if there's going to be an overspend. It's also important to have language in the notice in the advert, basically saying it's a framework. We honestly don't know how much we're going to draw down, but this is our best estimate. It might be more, it might be less. We know that that language isn't enough in and of itself. It didn't save the Danish authority in the Simonson and Wheel case, but it's better than nothing, and it certainly helps set the expectation of the market. And then when you're also publishing the notice telling everybody the outcome of the competition, the contract award notice, there is a box that says contract value, and just be careful what number you put in there, because if you have assessed based on an evaluation price that is conservative and only includes some elements of the tender price, you might give an artificially low impression of what the actual price was, and that might come back to haunt you when you are trying to argue that there hasn't been an overspend at a later date. During the tender period, just be careful about how you set expectations, especially on things like the contract. Like if you have really onerous contract terms, like really high insurance requirements, performance bonds that are maybe valued much higher than market, particular clauses on an allocation of liability that isn't market, you will probably find that that inflates tender pricing. And then if you then negotiate a different arrangement with your winner, if you drop any of those requirements, you are immediately into material change territory, because that clearly would have affected how people bid and could arguably affect the economic balance of the contract. So don't gold plate your contract at the start only to drop of those requirements at the end. Only insist on terms that you genuinely need to insist on, and they are your red lines. Because if you were to drop requirements at a later date with the winner, that could be a procurement issue. Contracting authorities have to deal with, a lot of governance requirements, the CNAG, etc. Make sure that in any internal documents with approval for the approval processes, there's clear descriptions of likely price, maximum price, realistic pricing, to make sure that people aren't given an artificially low understanding of what the spend is likely to be, only for there to be awkward conversations later on if it ends up being much higher. So if the overall approval is to include options, extensions, all of that. Make sure that's built into the governance to avoid any difficult conversations at a later date. And then contract management is obviously key. If contracts aren't carefully managed, scope creep becomes a very significant issue, and scope creep can lead you into dangerous territory, in terms of the safe harbors and Article 72. Unless you can find a home for scope creep in those safe harbors, you might find yourself having kind of sleepwalked into a procurement problem. So make sure that if there is not a clear, precise, unequivocal clause dealing with variations, that they are carefully managed and carefully considered. So like don't be extending the contract in its duration willy-nilly. Make sure contract managers are aware that the spend, especially on framework agreements, all potentially is contributing towards a procurement cap, and that if a framework agreement goes beyond that, there's a lot of legal analysis that has to justify it, and consider sort of, early warning systems on spend. So I suppose just key takeaways for everybody here. Procurement law does not end at the moment the contract is signed. There is a hangover that requires you to be conscious throughout the period of a contract to ensure that it's still the same contract that you ran a procurement process for. It cannot be subject to big changes unless those changes are justified by a safe harbor. So the best thing you can do is to plan from the outset to build as much as you can and as much flexibility into that procurement from the start. Clarify what options, what modifications, what changes might be required. Build in a mechanism for them from the start so that everybody understands the total potential scope of the opportunity. Make sure you're not insisting on things during the tender period that you might not actually die in a ditch over. Make sure that you are not gold plating things unnecessarily, because if you drop any of those requirements, you will find yourself in difficulty. And then make sure that you are monitoring and managing those contracts so that you don't end up in an inadvertent situation where the contract has been subject to a modification and maybe the analysis hasn't been done to determine whether it was appropriate or permitted. So, Grace, I will take any questions that might have come in from any of our participants at this point.
Brilliant. Thank you so much, Orla. There's a question in here. It's just asking if you could just explain what the acronym OEM stands for.
Oh, of course, apologies. Original equipment manufacturer. Sorry, that's my fault.
Perfect. No problem at all. Thanks a million. So the next question is asking, which of the tender documents is the best to include safe harbor in? And can you give an example of how you might add it, given provisional sums are not allowed in the PWCs?
Sure. So, I personally like to include the references to what I might need in both the prequal tender documents and also the contract itself. So, in the tender documents, it's a lot more loose language. It's a we may, we may, we may, and it can be honestly a shopping list of things that you might do. And honestly, that is often enough in and of itself, because that really shows that it wouldn't have affected who bid for this opportunity. They all knew that we might put an extra floor in this building. They all knew from the start that this might actually be a 10-year opportunity instead of a 5-year opportunity. So that's really the key place to include the big, long list of potential items. If it's something that you could possibly price, like say for example, it's a professional services contract and you're looking for a 5-year engagement, but you say it might actually be 10 years, depending on how things go. Um, you might then put in language to say, and if we extend it, we will take the existing rates, but uplifted for inflation or uplifted by X%, or something, so that you don't want to be in a position where after 5 years it's a complete renegotiation, because that would undermine the reason why that particular firm was appointed in the first place. So you have to keep a sort of straight line between why the particular winner was chosen and why they should therefore get the remainder of the opportunity, and some element of pricing that continuity, whether it's unit pricing to devise further rates, etc., or inflation, can be helpful. But I think the main thing, that the most important thing of all, because sometimes you can't price these things, is to make sure that the prequal documents are clear that the scope of the opportunity could grow and could expand.
Perfect. Brilliant. Thank you, Orla. And there's another question here is asking if a complaint has been raised, does the procurement have to stall? What's the solutions to prevent delays caused by complaints raised?
So it depends what you mean by complaint. So there is one mechanism that does put a halt to a procurement, and that is where proceedings are filed. So that means legal papers have been filed with the central office of the High Court. That is a step that is, it puts the kibosh on everything. You can't go ahead and sign your contract. You could, in theory, as an authority, take if someone challenges you at pre-qual stage, you could continue with the tender stage, even if someone was suing you. You just can't sign the contract. So you'd have to wonder, is that a good use of the authority's resources? I've never seen an authority continue if they have been subject to a formal procurement challenge filed in the High Court. If somebody writes an angry letter, there's nothing to prevent you from continuing. An angry letter is different from a formal procurement challenge, legal papers in the High Court. An angry letter might convince the authority that something has actually gone fundamentally wrong and that they should collapse and they should go back to the market. But it depends on how robust that complaint is. Sometimes it might be a complaint that the authority thinks there's no merit to that, and we're going to continue.
Okay. Brilliant. So the next question is a bit long. So it's saying on the PwC F1 Works contract, where a value engineering proposal has been submitted by the contractor to change the method of construction and design of the structure of the building, for example, from a traditional method to a modern method of construction approach. Would this be considered a material change rather than a VE proposal if it were accepted? This type of VE changes the design of the structure and changes the design responsibility in part from the design team to a potential MMC specialist appointed by a contractor.
So I'm not going to get into specific legal advice. That
Okay,
sounds to me to be a very specific question about a particular circumstance. I mean,
perfect.
the person who's raised this question is very live to the right issues. Like, honestly, that is a very good question. And I can't give any more detail than it depends. It sounds to me that
Okay.
that's exactly the kind of fine line question that would require a bit of analysis because there is a clause. The clause
Yeah.
allows for value engineering, but it could potentially be something that has changed the overall nature of the contract by reference to how the contract was advertised, those fundamental issues of design responsibility, etc. You can imagine that might have had a big impact on how people bid. So that would be one that requires a little bit more analysis, and I don't want to give an off the huff response, especially because it sounds like something that someone is probably facing into.
No problem. Thank you. There's another question here is asking, what are the potential implications if the CA leave the estimated value blank?
So in the Simonson and Wheel case, which of course was a framework agreement, that's exactly what they did. And the Court of Justice of the European Union was livid. And they kind of said you can't use the framework at all. Now, that case is very tricky because what they've also said is even if someone exceeds the value of a framework, we wouldn't suggest that means the contract has to be declared ineffective. So you've been a very, very bad boy, Mr. Contracting Authority, but we're not going to cancel this contract judicially. What's the teeth? It's hard to know, honestly, how this would be enforced. So, in terms of what are the consequences for the contracting authority, it is a breach of the obligation. I'm not even sure if the e-forms allow that anymore. They used to allow blank contract note values. I'm not sure if they do anymore. But you could find someone argues, I didn't bid for this because I didn't know if this was of the scale that was, in my wheelhouse or not. And if I had known that it was going to be a 10 million euro opportunity, I would have bid for it. You could equally go back and say, well, the others bid for it. They must have thought it was worth bidding for. It's hard to know in reality how that would come back to haunt them, but it's certainly not what they're meant to do.
Perfect. And there's another question here, Orla is asking if you could please outline the consequences for breaches. Who will enforce them?
So it depends. So we have seen one case in Ireland, only one case brought for a material modification, and we didn't end up getting into the weeds of that particular case because I actually won't get into it. It's too complicated as to why it didn't end up going to hearing, but it is possible to sue, basically. I think that's probably the first thing to say. If you are somebody who didn't get a contract and you see that the contracting authority has made significant changes with the winner, you have a right of action there. You probably would be looking purely for damages. You'd be arguing, if I had known that I would be allowed to make that change too, I would have priced differently and I would have won. It's a hard argument, but it's one that you can make. You probably won't get the contract struck down unless you can show that it's such a fundamentally different contract that it bears no relation with the original. So there's a UK case that says, even if somebody has made a change that is not strictly permitted by the safe harbors, but it's still kind of within the broad envelope of what everyone understood the contract to be. Like, it's still a contract to build a car park. It's not like a metro. Well, then you probably won't get the contract cancelled. You might just be looking for money, and you'd have to argue why you're entitled to money. In reality, what most authorities are more worried about is audit and governance and reputation. This is something that the CNAG is live to. This is something that their internal auditors are live to. And modifications of contracts can absolutely give rise to an adverse audit finding that can give rise to uncomfortable conversations before the PAC, Public Accounts Committee. Like, it is something that reputationally is quite problematic, and that's certainly something I'm seeing a lot in my practice.
Brilliant, thank you. And there's another question here, Orla. We might make this the last question, just looking at the time we're coming up to 12 o'clock. But the question is asking, in the scenario where a public project is broken out into two contracts due to the size, with one contract following the other, should the bidders for contract one be notified that there is a potential contract two to follow? And should the potential total value of both contracts be included in the tender documentation?
It depends if the expectation is that the project one winner will automatically be given project two. If that's the case, yes, all of that needs to be set in the front, in the pre-qual documents. All of that needs to be very upfront. If they are genuinely two different projects where you could have two different contractors, then it's much less meaningful, because even if you miss out on project one, you have an opportunity to bid for project two. But if the expectation is that the person who wins the first will get the second, that has to be included in the original scope.
Okay. Perfect. Brilliant. Well, we're just about coming up to 12, so we might leave it there. But thank you so much, Orla, for a fantastic presentation and for answering all of the questions that have come through today. And thank you to everyone who attended today's CPD. This CPD has been recorded, and the recording will be available on the SCSI CPD library within the coming days. So thank you all for attending. Thank you, Orla, and have a lovely afternoon.
Thank you, everyone.
Thank you.